cancellation, thanks to Eskom, we had to postpone. But I'm very happy to welcome Noah tonight. So Noah, as you know, has been, together Noah and I have sort of thought about some of our speakers and begun this, and I'm really excited that Noah's doing this talk. I think for many of us, I mean, this is a hard topic to think about, but a really important one. So we're going to be hearing more about wills and estates in the COVID era. Noah, as I think most of you know, is an attorney, and she's going to be sharing just some of her expertise and knowledge with us. Also, thank you very much to Rochelle from Happy Tales, who's very generously donated a voucher for our coffee club winner tonight. So we will, thanks Steve, we will do a lucky draw after the speech. And handing over to Noah. We've got some exciting talks coming up, which we'll tell you a little bit more about later.
Thanks, Aideen. So I just want to thank everybody for joining us. And to start, I just want to give a little bit of introduction on who I am. And I know some people on the chat know who I am, and some people don't know who I am. So just a bit of history. So I was born in Israel, and my family and I came to South Africa in 1989. It was 2 months shy of my bat mitzvah, and we didn't know anyone, so much so that I actually never had a bat mitzvah because we had nobody to invite. I didn't speak English. We were put at King David Sandton, and funnily enough, there were no Israeli kids in the whole of the school. And my sister and I were the only Israeli kids, and the Hebrew teachers became our friends. It was a rough ride. And I did Standard 5 at King David Sandton, and then I moved to King David Linksfield. And I always knew that I wanted to become an attorney, so much so that when I was in grade 3, it was the early 80s, and Madonna was all the rage. And I remember all the little girls, when you asked them what they wanted to be when they grow up, everybody used to say, oh, when I grow up, I want to be Madonna. And I actually always used to say, I want to be Madonna's lawyer. And when I finished school, I knew exactly what I wanted to do. I went to varsity. I did a BA in law. I then did a postgraduate LLB, and then I did an LLM. And when I finished studying, we started as attorneys. You have to do articles. And in 2001 until 2003, I did my 2 years articles. I was admitted as an attorney in 2003. In 2004, I was admitted as a conveyancer, and also opened my own practice. So my practice is called Noah Kinstler Attorneys. And I run a general practice, which means I basically deal with many aspects and facets of the law. On the personal side, I have 4 boys at home that I need to take care of. I've got 3 magnificent sons and my husband, Greg. And why the topic? So the topic does seem a little bit morbid, but you'll see throughout my talk, it's actually not a morbid topic, and the talk is going to be quite light. A few weeks ago, I got a call from a client with my first COVID estate, and I thought to myself, families are just so desperate. They're going through the nightmare of having a family member in ICU dealing with COVID, and then the unimaginable happens and they become one of the statistics. And I thought to myself, it is so important that the family doesn't have to deal with the administration and the nightmare of dealing with the master and dealing with the idea of what now and what do I do now and how do I deal with it. So to start off with, there's just the simple question of what is a will? So a will is a document, and in that document, a person actually sets out what he or she wants to happen to their estate when they die. And a will basically deals with the estate. And what is an estate? An estate is the person's property, belonging, but it's also the debts that they have at the time of their death. And to administer an estate means that somebody collects all the assets, takes control of all the assets, pays off all the debts, and thereafter pays the balance of what is left over to the heirs. Now, who needs a will? And the answer is every adult needs a will. And I'm going to tell you about a client of mine, and I'm not going to divulge any names because of attorney-client privilege, but this is an estate which I'll call Estate Late K. Now, a few years ago, about 4 or 5 years ago, Mrs. K and her son, who was about 21 at the time, came to see me on a Friday. And they said that Mr. K is in hospital and he's desperately ill. And they asked me to prepare a will for him. And they basically told me, Mr. and Mrs. K are married in community of property. He wishes to leave his entire estate to his wife. That weekend, I actually drafted the will, and on Monday, I got a call from Mrs. K to say that Mr. K has actually passed away over the weekend. That meant that Mr. K died without a will. Now, there were several problems with this kind of estate, because when you die without a will, half of the estate automatically did go to Mrs. K because of their marriage in community of property. But the other half had to be divided between Mrs. K and the 4 children. Now, yes, 1 child was a major, but 3 other children were minors. And the problem with that was that there was a bond over the property. Mrs. K said, I'll take over the bond, but she couldn't be the full owner of the property because the children also inherited the property. And we had to actually bring an application to the High Court to request the court for permission to make the children debtors in terms of the bond. This caused major delays. It caused a lot of unnecessary legal costs. We finally were successful with the application, and we submitted what is called a liquidation and distribution account to the master. And a few weeks later, we were expecting the master to provide us with permission to advertise, and so that we can now distribute the estate, let Mrs. K receive the estate. And we received a letter from the master to say that there is a woman that approached the master with 2 minor children, and it came to our attention that Mr. K actually had a secret family, a second family that nobody knew about. The deceased is now died 5 years ago. We are still dealing with the estate. Now, had Mr. K signed his will before he passed away, the estate would have passed to his wife within 6 to 12 months, and all these problems would have not arisen. So that's just an example of what can happen if you do not sign a will. Who needs to sign a will? Now, the master of the High Court is the authority of who deals with estates. And a death needs to be reported to the master. Now, not every death needs to be reported to the master. There are 3 kinds. The first one is anyone who dies within South Africa that leaves property, whether there's a will or not. The next is anyone who dies in South Africa who leaves a will. So very possibly this person does not have property, but he leaves a will, he or she leaves a will, must also be reported. And lastly, a person who dies outside of South Africa, but leaves property within South Africa or a will within South Africa. Now, what else is a very important reason to have a will? Well, when you're a parent, it's very important to have a guardian for your children. Now, many parents don't realize that if they don't actually set out who will be the children's legal guardian, it could be Auntie Jane, and Auntie Jane must be maybe very well financially secured, but she might not be a very nice person. The expectation is usually that the spouse will take care of the children, but what you can't discount is spouses passing away together when there's a tragic accident, for example, or spouses passing away at close proximity. Another example of a family that it was an estate that I dealt, well, it wasn't an estate, it was a case that I dealt with in 2009, and I'll call it estate late H. It was a terribly, terribly tragic story, and it was in the news. It was a Chinese family. The grandfather was 84 years old, and he lived with his son, his wife, and their two minor little girls. And one evening, the grandfather took out a gun and he shot the mom and the dad. He shot his son and his daughter-in-law. And the two little girls remained. Now, what he did was, after he shot his son and his daughter-in-law, he just went outside. He sat on the grass on the front garden outside, and he phoned his other son and said, I don't know what came over me. I don't know what I've done. Now, I got involved because there were family members that now were wondering, what are they going to do with these two little girls? There were family members from Canada, Australia, Johannesburg, and Port Elizabeth. Two aunties and uncles were from the mother's side, and two aunties and uncles were from the father's side. And while obviously the father's family was completely innocent, it was still the grandfather that had killed the daughter, the sister of the mother's side. Now, I got involved in order to appoint something called a curator for the children, because the children needed to be represented. There was no will, and there was a decision had to be made of where those two little girls will go. We had to appoint a curator, so we had to approach the High Court, and we had to involve social workers, we had to involve attorneys, we had to involve advocates, we had to involve a curator. And the problem that arose is that that kind of action actually costs a lot of money, and that money was paid out of the estate. Now, that's money that should go to the children. But in order to make sure that the children have guardians, there was, and if I remember correctly, the accounts of everybody, the social workers, the advocates, the curators, etc., was well over 250,000 Rand. So had the parents left a will whereby they discussed who the children's guardian would be, this whole situation would have been avoided. I am still in touch with the uncle and aunt who were appointed as guardians of these two little girls. Both little girls, the one has just finished high school, and the other one is in, I think, her grade 11. And they stayed in Johannesburg, although there was an idea to send them to an auntie in Canada, but it was decided that they would stay in Johannesburg. And the story had a good ending, but it could very well have not been a good ending. So having a will when you're a parent of minor children is crucial. It is so important. I will also later on deal with what happens to the children's inheritance if a child is under 18, and I'll discuss the Guardians Fund. Another reason is a lot of people say, well, I don't have any assets, so I don't need a will. I've got nothing. I rent a house and I live on my salary, and maybe I have a car and a couch. And that's also not a good idea, because in your will, you can also discuss special requests that you have. Who will take care of your pets? As an example, I once heard, and I haven't seen it as legislation, but I once heard that if you have a parrot, one of those beautiful tropical parrots, they live until they're 80, and apparently you should state in your will who should take care of your parrot. But something a lot more important is your burial wishes. And there was a case in East London last year in 2019. It was an urgent application that was brought before the court by the parents of their deceased child against the wife. And they brought an urgent application to stop the wife from burying the deceased husband. And the facts of the case were that the parties were actually separated. So there was a divorce summons that was issued. Although they were still living in the same house, they were, for all intents and purposes, separated. And the deceased actually passed away from what was suspected to be a poisoning. And the parents didn't want the wife, the estranged wife, to bury their son. And what the court found is that they had great sympathy for the parents, but because the deceased did not leave a will with wishes, his burial wishes, and because the wife, the estranged wife, was still his wife by law, she got to bury him. The parents had absolutely no say in how their son is going to be buried. So that's another example of why a will is just so crucial. So again, the question is, who needs a will, and why is a will good? What is it going to help? So number one, like I said, when you have a will, you decide how your estate will be distributed. A will tell you the who, the what, the when in regards to your estate. It will also decide who will take care of your minor children. And this is where I bring in the issue of the guardian's fund. Should you pass away without a will and your children are the heirs to your will, if they're under the age of 18, they cannot inherit. That means that their inheritance will only come to them when they turn 18. So the question is, what happens to their inheritance until they're 18? And the answer is, it gets paid into something called the Guardian's Fund. Now, the Guardian's Fund is administered by the Master of the High Court. And basically, it's funds that are held together for either minors, persons that are incapable of managing their own affairs, unborn heirs, or missing and absent people. Now, the master will receive the money. The master will then open an account in the Guardian Funds, in the books of the Guardian Funds, in the name of this child. And the money in the Guardian's Fund is actually invested with the Public Investment Commission. It's audited annually, so there isn't a risk of the money disappearing, but the interest that runs in the Guardian Fund is very minimal. It's a minimal rate. It's not like as if you would put your the inheritance in a money market or anything like that. The other thing is, what happens to maintaining these minors? These minor children need to be maintained. Now, the guardian of the children can make an application to the Guardian's Fund to receive funds in order to maintain the children. And that includes school fees, clothes, medical fees, boarding and lodging fees. All that needs to be motivated to the Guardian Fund, firstly. Secondly, the money will be paid from the interest that is earned. And again, if the estate is not overly large, the interest is not going to be sufficient, plus up to 250,000 Rand from the invested capital. So if you think about what kids cost these days, and just simply looking at private school education, it's a big problem for the guardian of these children to be able to maintain the children. Another reason to have a will is to avoid a lengthy administration process. So, contrary to common belief, all estates need to go through the master. But if you have a will, it will speed it up. Another reason is that it will minimize the estate duty. So now, estate duty in South Africa, you have to pay tax on your estate. It is 20% of your estate for anything over 3.5 million rand up to 30 million rand, and anything over 30 million rand is 25%. Now, if you have a will, the person that sets your will, that drafts your will show you certain ways to reduce estate duty. For example, putting the first 3.5 million rand in a trust. The next thing, the next reason why you should have a will is because then you will decide who will wind up your affairs. So the executor is the person that's going to wind up the affairs. They will collect all the assets, they'll pay off all the bills, and then they'll notify the banks and the business establishments of the deceased. Now, because executors play the biggest role, and obviously whatever the executor does is being overseen by the master, but it's very hard to control an executor unless something is reported to the master that something is not right. So it's very important for you to choose an executor that you trust. Another example of something that I have come across is, I'll call it estate late R. It was an individual that passed away. He did have a will, and in his will, he appointed his brother as the executor. Now, his brother was also his business partner, and he trusted him, and he didn't think there would be any problem. I wasn't involved in it yet. A few years later, the estate still wasn't administered, and the mother passed away. There were minor children, and what the brother did was he continued the businesses, but he never wound up the estates. So when the oldest child gained majority at the age of 18, he started asking questions because he remembered that his father had several butcheries and he had several properties. And the brother couldn't answer any of the questions. And that's when he approached me and we started investigating. And we found out firstly that the brother never ever wound up the father's estate. And the other thing that the brother did was he convinced the mother of this child, who was at the time very, very ill. She was on her deathbed with HIV/AIDS. And he made her sign a will transferring all her rights in her husband's estate to him. We had to approach the court. Actually, around August last year, we were able to set aside the deceased mother's will, and we are now winding the estate for the benefit of the children. So that is just another reason to make sure that the executor that you appoint is somebody that you trust. Another reason why a will is important is that you can disinherit individuals. So some people don't know this, but you can disinherit individuals. You don't have to, in South Africa, I know that in some European countries your children have to inherit, and they've got certain rules, but in South Africa there's a complete freedom of testation. That means that you can disinherit individuals. For example, an ex-spouse, I've got another, I will deal with it a little later on, of some reasons why you would want to disinherit somebody. In your will, you can make gifts and donations. Should you pass away without a will, there is no option of donations. I've seen some wills where people leave a certain amount to the Gev or to the SPCA, or to any sort of charitable organization. And should you die intestate, there is no such opportunity. The other thing is to make specific gifts. So some people would like to give, for example, their candlesticks to their daughter, or jewelry, wedding rings, specific jewelry to specific people in their life. When you write a will, you actually specify who should get what with regards to gifts and personal belongings. If you die without a will, your estate may pass to somebody that you didn't intend to pass. Now, there was a case that involved a deceased son who actually won 10 million rand in damages. So his estate was worth 10 million rand. And very shortly after he won this court case, he passed away. And the person that inherited this 10 million rand was his estranged father, who hadn't seen his son for 32 years. And his close relatives and people that we assume he would have wanted to inherit were actually disinherited, which is again tragic. And the only way to have avoided this was to leave a will. You can always change your mind when circumstances change. So a will can always be amended. Life changes, there's births, there's deaths, there's divorces, there's situations that mean you have to change your will. Can always be amended. And also another reason why you need a will is because tomorrow can't be promised. Many people procrastinate. They're unwilling to accept death, and they just don't sign a will. But sometimes the realization that wills are necessary come too late. And I have had a client sign a will in ICU. It's when families are emotional, when the person itself is in an absolute state because they're facing possible death, and it needs to be avoided. So the question then is, how do I draw up a will? It can be as easy as downloading a template from the internet, but my suggestion is to approach a professional. It could be a practicing attorney, it could be the bank, and it's very important that the will is drawn up correctly. Now, like I said, in South Africa, freedom of testation is very, very wide. But freedom of testation, so something that you leave in your will, can actually be limited. And one example was in the early 1900s, there was an extremely wealthy individual that left money in a trust, and it was for a bursary. And I can't recall if it was Stellenbosch or UCT. It was a bursary that continued year after year, so it was a large amount of money, and it was obviously invested over the years. But one of the requirements for the bursary was that the beneficiary would be of European descent. It was in the early 1900s. And this, a couple of years ago, was challenged in the courts, and that requirement in the will was taken away. It was found to be unconstitutional. So the question then is, what happens if you state in your will that the heir cannot inherit if they marry out of the Jewish faith? So it's something that is very interesting, and it's been going on for many, many years. In 1944, there was a case, the Wasserus case, and it stated as a condition that the heir cannot marry out of the Jewish faith. And the judge in 1944 said, no, that's too vague, it's not enforceable. In 1950, there was the Aronson case, and the judge found that the sentence that says, the heir shall not marry a person not born in the Jewish faith or should not forsake the Jewish faith, was valid. And the judge said, if the heir does not marry Jewish person, they cannot inherit. And today we look at it and we say, well, what is the question? The question is basically for a judge to choose between freedom of testation and freedom of religion. And they've described it as an agonizing choice. In 1960, there was a case, it was the Greenberg case, and it was found that such a clause in a will actually gives the deceased the power to do in death what they could not do in life. And they found that there's just no room for forgiveness after death, and there's no room for relenting, and it was thus rejected as an enforceable wish. Now, today, obviously, a long time has passed since the 60s, and I haven't been able to find a current case about it, but if you look at everyone's entrenched right to freedom of religion, I have no doubt in my mind that if such a clause is challenged, a court will set it aside. It's just an interesting thought. Again, when you draft your will, like I said, it's very important to to appoint an executor that you trust. However, something else that is to think about is that the administration of a state is quite a complex process, and there are many legal requirements. And what is suggested is that you ensure that you nominate someone that would know what they're doing. You don't have to nominate the person who drafts your will or the institution that drafts your will. That is not a requirement. And you can also appoint more than one person simultaneously. That works for several reasons. Firstly, when there's two people overseeing something, fraud, deception, forgery, etc., is a lot harder to pass. And also, if one person as a nominated executor is unable to do so, there's always one other person that can stay as executor. The prescribed fee for an executor is 3.5% of the value of the estate. So the heirs do not have to pay an executor up front. It actually comes out of the estate. But in your will, if you do draft a will, it is very possible for you to actually indicate a different fee in your will that you want your estate. So, for example, I've drafted a will before of an incredibly wealthy individual, and he said, I'm prepared to give 1% of my estate. Now, because such an individual, the estate is so large, any executor would accept that, because you can get 3.5% of a small estate or 1% of an extremely large estate. Many executors would accept it. So it's something that's negotiable, and it's something you should discuss with the attorney that's drafting your will. Something else is you should make sure that all the gifts that you leave to your beneficiaries are clearly described and clearly stated, so that the family members understand and know what you are referring to. Use clear language. Don't use a lot of legal jargon. Try and make it as clear as possible. A will needs to be signed by the testator, which is the person that leaves the will, on every page, and it needs to be witnessed by 2 witnesses. Now, some people believe it has to be before commission of oath. That is not correct. The only time it needs to be before commission of oath is if the person is unable to sign and makes a mark. And then a commission of oath would need to append a certificate to the will. A will must be signed on every page before the 2 witnesses. The 2 witnesses cannot be heirs named in the will, or the spouses of such heirs, because they may not be entitled to inherit. Something else that's very important is to date your will. So if there are previous wills, there'll be no argument as to which will is the latest version. Update your will regularly. It's advisable that once a year you have a look at your will. For example, if a bequest is made in a will to a divorced spouse, the Wills Act stipulates that a bequest to your divorced spouse will be deemed to be revoked if you pass away within 3 months of the divorce. However, once 3 months have passed and you forgot to update your will, the bequest to the divorced spouse stands. And something that may seem really, really obvious is ensure that your loved ones know where the will is. The master will request the original will. It needs to be originally signed. So what we often recommend is that you sign 2 originals. You leave one with your attorney and you give one to one of your loved ones and make sure that they know where it's kept. Who will be disqualified from inheriting? So like I said, the person or his spouse, if somebody hand writes a will, the person or his spouse will be disinherited, or a person or his or her spouse that signs the will. But there's an interesting concept. Can a person who intentionally caused the death of the testator inherit? And there's a Roman Dutch concept called die bloende hand erft niet, which means the bloody hand does not inherit, which makes sense. And I don't think anyone would argue with it. But then the question then is taken further and says, what about if the heir caused the deceased death by negligence? For example, in a car accident. And legal scholars have debated this. And legal authority says the rule is that if you caused a death, you cannot inherit. However, they've added the word morally reprehensible. So an example is a 1992 case where a husband shot his wife in error. He was playing with his firearm. He was slightly intoxicated. And they found that he could not inherit because his conduct was found to be morally reprehensible. Now, we are lucky to live in modern times because there was a case, Taylor versus Pym, in 1903, where an heir was disinherited because he was found to be morally reprehensible for leading the deceased to live an immoral life by drinking alcohol. So, a sign of the times. Things do change in law and in terms of modern lifestyle. I'm not sure if I've still got more time. Aideen? Should I just carry on?
I think we're good. We're good for a few more. We're good for a few more minutes. Okay. It would be good to leave some time for questions if possible.
Okay, so I've got quite a bit more to talk. I can carry on for another 2-3 hours, but maybe you just stop me when I run out of time.
Okay.
So the question then that is brought up is, what will happen if I don't have a will? How will my estate actually be divided? And a lot of people believe that the state, the government will take over your assets, etc. That is not accurate. So the way that your estate will be governed is in terms of legislation. It's called the Intestate Succession Act. The act was passed in 1987. And the way that it works is, if you are married in community of property, it means that automatically half of your estate goes to your spouse. But this is how it works. If the deceased is survived by a spouse, but not by descendants, meaning not by children, then the spouse gets the full estate. A question then arises, who is a spouse? What is the definition of a spouse? So it's very easy in terms of a civil marriage. It's very uncomplicated, and that's where the uncomplication stops. There's been a lot of changes in our law currently in terms of a customary marriage, because one has to look at the customary laws of succession versus the common law of succession, and there's actually been a lot of development currently with regards to customary marriage and how the estate is divided in terms of a second wife and a third wife, etc. Something else that was quite complicated but is now recognized is that Muslim and Hindu marriages are actually not recognized as marriages in terms of South African law if they're not registered as civil marriages. And now, in terms of current law, they are recognized as valid marriages in terms of inheriting intestate. Before December 2006, if people were partners in a same-sex life partnership, they were considered spouses. It was a constitutional court case. However, after that, when the same-sex relationship where you could marry in terms of the Civil Partnership Act, now if you're in a same-sex relationship but not married, you are not considered a spouse. So after that, you look at what happened if the deceased is survived by children but not by a spouse. Then the children will inherit in equal shares. What happens if the deceased is survived by a spouse and children? Complicated again, because the spouse will inherit either 250,000 Rand or what is called a child share, whichever is the greater. You then start calculations. You take the child, how you determine the child shares, you take the estate, you divide it by the number of surviving children. You look at if the surviving children are deceased, did the surviving children leave children? And you add the surviving spouses. So, for example, in a customary marriage, it could be more. So again, it's complicated. It's just very hard for the executor. If a deceased leaves no spouse, no descendants, then his or her parents will inherit. If the deceased leaves no spouse, no descendants, but one parent, then the surviving parent will inherit one half. The other half will be inherited by the descendants of the deceased parent. So you look at it and you go, it goes very far, because your father could have had stepchildren, half children, or anything. You know, it just goes very far. Your estate is just not given to the people that you would want to. What happens if the deceased leaves no spouse, no descendants, and no parents, but the parents have left descendants? Then half goes to the descendants of the mother and half goes to the descendants of the father. And so it goes on. What happens if the deceased does not leave a spouse, does not leave a descendant, does not leave parents? The parents do not leave a descendant. It goes to the nearest blood relative. And lastly, if the deceased is not survived by any relative, that is the only case where the inheritance and the proceeds will go to the state, to the government. There were quite a few controversies with regards to children. At the time, there was a concept of children born out of wedlock. And it was found that children out of wedlock can inherit the same as blood relatives, the same as a child in wedlock. And something else that was also discussed was, what is the position of adopted children? And again, an adopted child is deemed to be a descendant of his adoptive parents, and they are not considered to be a descendant of a natural parent. So that's just an intestate. This is intestate succession, basically. So I've basically spoken for 45 minutes about a really morbid subject, but I hope that what I've done is just put it forward on how important it really is to have a will, so that your family and the people that you leave behind know what to do, know how it's done, and take the burden off you, take the burden off your family. So I don't know if there are any questions. Aideen?
I was going to say, if people would prefer to post on the chat, we can read them on the chat, or otherwise you're welcome to unmute can people unmute themselves, or do we need to unmute? I'm not sure. You're welcome to unmute yourselves if you want to ask any questions.
People can unmute themselves.
They can. Thanks, Steve. Let's just give a few minutes here. It looks like there might be a question coming through. This has been really fascinating and quite scary. We don't have affairs in order. People are very quiet.
Hello, can you hear me?
We can. Hi there.
Hello, can you hear me?
We can.
Doctor.
No, a difficult one. Just really hypothetical. You have we often are seeing now same-sex marriages, and let's take two women. The one woman has had an in vitro or sperm donation. Now, what would happen there if there was a breakup of that marriage? Is there any difference because that child, and let's say the mother who carried the baby died, would there be, how would one look at it that way?
So the question would be, the mother that did not carry the baby, did she adopt the child? Because she wouldn't be the biological mother of that child. And
Right.
I beg your pardon?
No, right, I say right. Oh, yeah, yeah.
Yes, yes. So in a same-sex marriage, when one mother is the biological mother of the child, the other mother, the other wife, which would be the mother, would need to legally adopt that child in order for that child to fall into intestate inheritance. Also, with an in vitro and surrogacy, etc., they actually part, because it's a fairly new aspect in our law, and they actually passed a legislation whereby surrogacy, there needs to be a surrogacy agreement that needs to actually be sanctioned by the court prior to the child being born. It's quite a specialized field of the law, but yes, there are legislative steps that need to be followed.
Oh, thank you.
Any
Anyone
other questions?
else? I love answering questions.
I think the lack of questions is because you presented a really comprehensive, fascinating talk. Thank you.
Thanks, Aideen.
Oh, here comes a question from Laura de Villiers. Hi, Noah. How does a will in another country affect your estate in this country?
So it's a very good question, especially with a lot of us making Aliyah and living in different countries. What I recommend to my clients is that if they own other property in other countries, I recommend that they actually draft a will in that particular country. And the reason for that is that not many countries actually have a state duty, a state tax. So for example, if you own a property in Israel and it gets reported as part of your assets in South Africa, you would need to pay 20% estate duty on that. So it's always my suggestion that should you have properties in other countries, is to make a will in that country and try your best not to bring that property into your South African estate.
Noah,
Yes.
what would have happened with that case that the grandfather killed the parents? If they had a will and they had made that grandfather or father, their father, the
guardian.
the guardian.
So that's very interesting, because it could go back to the concept of the bloodied hand cannot inherit, but becoming a guardian of a child is actually not per se an inheritance. But what would have had to happen is, again, the family of those children would have had to approach a court to get a curator appointed, and that curator would bring a High Court application to have his guardianship set aside. Now, the High Court is considered the upper guardian of all minor children. So whenever anything to do with children, and it's got to do with divorce, it's got to do with death of, but anything, sometimes there's some cases, actually very interesting cases, there's certain religion that doesn't allow blood transfusions, and you would see doctors approaching the High Court to insist that a child gets a blood transfusion without his parents' consent. And the court can do that because the High Court is considered the upper guardian of all minor children. I see there's a question, has there ever been a case of an estate being left to a pet? So I'm not aware of such a case in South Africa, but I know that one of the French designers, I can't remember his name, but he did leave quite a bit to his cat. And I know that it was a German lady who left her entire estate to her dog.
That's a great question.
Noah?
Yes.
Hi, long time listener, first time caller. Just a quick question. You mentioned the estate overseas and not bringing it in. What happens if it's already in my local estate? Is there anything I can do to avoid that or to take it out?
Unfortunately not. Once there is an immovable property within South Africa, it's impossible to take it out because
what if I transfer it to a family member?
I beg your pardon?
Am I able to transfer it to a family member perhaps while I'm alive?
While you're alive, absolutely. You can transfer it to a family member while you're alive. But you must just remember that there's transfer duty implications and all sorts of tax implications. But while you're alive, you're welcome to do what you want with your property.
As long as it comes to me.
Yes, the question was whether I should do it, whether it would be a good idea to transfer it to a family member who lives overseas.
If I'm the family member, then the answer is yes. But any other, it's.
Right, imagine you calculate the estate duty, right? And how much it would cost on transfer duty and weigh up the options, I assume.
Yes, and the transfer duty will probably be substantially less than 20% of estate duty. But don't forget, if the property is worth less than 3.5 million, and that is your only property within South Africa, then there is no estate duty payable.
Thank you very much.
Great. Any other questions? Comments? So
I just want to say that if anybody's got any questions or anything, you can email me or give me a call. My cell number is on the ladies group, and my email is easy. It's Noah, N-O-A @Kinstler. That's my maiden name that I practice under, KINSTLER.co.za, and I'll gladly answer any questions with regards to wills and estates, but also, like I said, I run a general practice, so I can pretty much answer many legal questions and solve legal problems.
I think on behalf of everybody, thank you for a really interesting, stimulating talk, and thank you everybody for all your really interesting questions. So it's time for us to do the lucky draw. Michaela is back. So let's that you can help with the random number. I've given everybody a number, and some of you, I might not have a full name, but just like the name of your device. Okay, so here we go. Yeah, we're going. Number 11, Helen Miller is our winner. So you have won, thank you, Rochelle from Happy Tales, a special dog grooming. So if you wouldn't mind, Helen, just sending me or just putting on the chat your just your contact details. I'm sure we've got them, but if we could, then we'll be in touch afterwards. Sorry about that.
Thank you.
Just to say thank you to everybody who has attended and been part of tonight, the people who are regulars of our community and guests. We really are so grateful and happy that you all attended. We've got some really interesting talks coming up. The next one is Lauren Davis, and she's going to be talking about Professor Ruben Feuerstein and Changing Destiny, a really inspiring, interesting talk. And after that, we've got Stephen Siegel, who's going to be talking about the Jewish communities of Mumbai. Is that right, Steve? Did I get it right?
Almost. But
Tell
I'll
me
give you,
again.
hey, what was it? Similar to that,
Okay, perfect. We'll send out the official, all the official certificate, at least topics. And then just a reminder, we would love people to contribute and talk, whether it's an area of expertise like Noah shared with us tonight, or an area of interest, or just something that's inspired you. That's what the Coffee Club's about, sharing, bringing light to each other through what we can bring. So thank you so much, everybody. And yeah, stay around if you want to chat. Everybody's welcome to unmute. Otherwise, we'll hopefully see you all soon. Thanks again, Noah, for a brilliant presentation.
Thanks so much. Thank you, everybody, for sticking around for the full hour.
Thank you, Noah. It was a great talk. It was really lovely. Thank you.
Thank you. Thank you.
Thanks, Noah. It was wonderful.
Okay, lovely to see you all, and great. We'll see you all next time.
Looking forward to next week, everybody. Lauren is just such a lovely, she's got an amazing topic, and she's an excellent speaker. So we really are looking forward to seeing all of you at our favorite coffee club next week.
Thanks, Noah.
It's a pleasure. Thank you, Vicky. I'm honored to be following your talk. Your talk was amazing.
Thank you, Noah. This was so insightful. It was brilliant. Thank you.